ruling that changed government forever. No one is underestimating Galati in his latest fight over the Bank of Canada's business. His cases can seem improbable, but Galati has a long history of coming from nowhere to win. In the second part of our conversation, I wanted to know more about what motivates him and why he thinks governments need challenging.
I've been taking on government successfully since the mid-90s, and in 99 at the Supreme Court level. I have sued ex-Prime Minister Chrétien's government and Prime Minister Chrétien more times than I've sued the current government. For me, it's not about a particular government. When government goes astray, in a constitutional democracy, there are only two checks and balances to a government going astray and going wayward of the law and the Constitution. One is the opposition in Parliament. One is the parliamentary system, which in my respectful view, starting with the Prime Ministership of Jean Chrétien, became pointless and useless. It's a charade. The other more important balance to executive action and parliamentary excesses of the Constitution are the courts. That's the only, if you take away the courts, then you have what I say has been happening slowly in Canada, is a quiet dictatorship. If you take the judicial check and balance away from the executive and parliament, you have one-man rule, unrestrained.
Which I think many will argue is the ultimate importance of the Nadon case.
Of course, that's why I took it on. I saw an attempt to pervert and subvert our independent judiciary, which is the last bastion of balancing the rights of the citizens as against the government and making sure that the government doesn't turn into a dictatorship. If you can stack the court and corrupt the judiciary, well, that's it, it's complete.
Do you believe that the way the court ruled on that, the language it used, the expression, is an acknowledgement of that the court needs to protect itself from meddling?
Clearly, that's why it constitutionalized itself. Most people don't understand the seismic importance of that decision. It said, you can't do anything with this court without the consent of all 10 provinces on a constitutional amendment. Something that would not have been affected if they tried, because you can't get 10 provinces to agree. And so, yeah, that was the seismic import of that case. It protected the court. The court took the occasion, by us bringing the case to the court, to constitutionalize itself.
Is it frustrating to you, when you look back, the way that case was covered, it never did point to that issue.
Oh, yeah.
It's only in the aftermath that people will look back and say something important happened there that was a good, important thing. When it was being covered, it was, who is this pesky guy? Why is he chipping away at the Prime Minister? You know, what does it matter? Is that frustrating?
That's frustrating, but I have a long history of this in terms of, you know, back in the 90s, I challenged the constitutionality of the Multilateral Agreement on Investment in the OECD. I was a lawyer who went to the Supreme Court, didn't get leave on the 201 Summit of the Americas in Quebec City for the protesters, and we challenged the FTAA, that trade deal. And so I'm used to this. In a lot of my cases that I win, in every single case that I take, the government response is always, it's ludicrous. The press saying, what's he going on about now? It's got no merit. And in fairness to the government, in 37% of the time, they're right. I lose 37% of my cases. But in the other 63%, they still have the same mantra. It's no merit. Let's get it out of the courts. But you know, this is part of the battle that you go through when you engage in constitutional litigation.
You're not doing this to get rich.
No, I'm not doing this to get rich. I could, you know, I'm a tax lawyer by training and profession. If I wanted to be rich, I do nothing but tax cases. In
fact, even in some successful cases, you have spent more than you've been awarded in costs.
Well, in the Nadon case, I put out $42,000. I was awarded half of $5,000, including HST and disbursements, which means I was awarded nothing.
So you're essentially making a personal investment in these cases.
As a citizen, as a lawyer, yeah. Somebody's got to do it. It's like the challenge we brought to the new Citizenship Act, which is now in the Federal Court of Appeal, where they purport to be able to strip a Canadian-born citizen of his citizenship or her citizenship. I mean, that's been unheard of since 1608, when they tried it for the first time, and 14 judges, including Lord Cook, said, no, you can't. If you're born here, that's it, end of story. So,
why aren't there more lawyers doing what you're doing?
Primarily 3 reasons. One is that every lawyer in the country, except 2 of us, me and my associate that I've met, wants to be a Supreme Court of Canada judge. It's a bit delusional, but everybody is a titan in their own mind. Secondly, People don't, people have to raise their family and pay their expenses. They don't want to be liable to personally pay these costs. And thirdly, to be frank, we do a bad job of teaching and encouraging constitutional law and thinking outside the box and thinking that there is something more supreme than Parliament. Because when we patriated the Constitution, as the Supreme Court has pointed out many times, we no longer live in a parliamentary supremacy. We live in a constitutional supremacy. And so Parliament has to keep within the limits of its powers.
You, in fact, one of your early victories was forcing governments to be accountable for decisions that they make, for rulings that they make.
Yeah.
And I think in legal circles, people would point to that as a hugely important development.
Right.
For the
in 1999, I co-counseled for Roger Rowe, who was the prime counsel on the Baker case, which broke 200 years of administrative law that said any time a government official makes a decision that affects your life or livelihood, they have to give you written reasons. It wasn't the law before that. But more importantly, that case also ruled something else, that when interpreting domestic Canadian law, we must comply with international treaty norms, whether we've signed the treaty, whether we've ratified the treaty or not. We are the only country in the Western world in any democracy that has that ruling, which keeps us in check so we don't go too far astray.
How do you decide whether a case is something you want to do or not?
I tend to decide on whether or not it has to have a constitutional issue, and it's got to go to the integrity of governance or the violation of somebody's rights, that are human rights or charter rights. That's how I decide to take a case. Otherwise, if you want a divorce settlement, you go somewhere else, because I think reasonable people should reasonably solve their own private problems. I only do cases against the government because when the government's after you, there is no making a deal.
And have you paid a price other than obviously the costs that can be involved, the personal time commitment? Have you paid a price for that, for being this thorn in the government's side over time?
Oh, I'm sure. I'll never get a judicial appointment. I've never had an interview when I've applied to teach at law faculties. I've applied 147 times, never got a single interview. And so people personalize things. They don't look at the issues often. They don't look at the person. They simply make a prejudgment of the issue through the lawyer. And Aristotle told us, don't judge the messenger, judge the message. And so I'm okay with that in the sense that, it is what it is. That's our culture. We tend to bring it to that level. Other societies don't. In the States, they openly litigate things without personalizing it.
And in this case, what is your hope? What changes post the ruling that you're hoping for?
Right. My hope is that the court declared that the government is bound by the legislation and cannot simply hand over that decision-making to foreign private bankers. What the government then does is up to the government, but they can't simply arbitrarily say no, never again when the law is there and the history of the reason for creating the Bank of Canada is there. Most people should realize we use this Bank of Canada interest-free loan mechanism to pay for World War II, the Trans-Canada Highway, the St. Lawrence Seaway, and all the explosion of all the universities and hospitals and schools that were built in the 60s up until 74 were all built using interest-free loans from the Bank of Canada. And you know what? It didn't affect inflation in the least. In fact, the inflation rate since 74 to now is much higher than it was from 38 to 1974.
All right. So, we got to leave it there. We appreciate your time.
Thank you.